So, belligerent in court, what is that? Well, it's about fighting for your rights and why belligerents are actually welcome in court. And if you don't know your rights, a court is under no obligation to inform you or to protect you, your rights. Even if you know your rights but don't fight for them, the court is under no obligation to protect you. I repeat that. The court is under no obligation to protect you. However, you have to know how the system is supposed to work in order to fight intelligently. Otherwise, the court will proceed against you and ignore your rights on a presumption that you waived your rights because you didn't claim and fight for them. In the legal system, almost everything is presumed. Now, a police officer, for example, they'll assert wrongdoing on your part, and if you don't contest or dispute the asserted presumption of wrongdoing, then by the rule of tacit admission, then you've agreed that the assertion is true and correct, plus it isn't about justice. And by that I mean it's all about commerce. Something is going to make money, someone is going to make money on your misfortune, but only if they can attach the asserted presumption to you. You do not have to accept any unlawful charges brought against you, and it really is that simple. So you can learn how to compose your own affidavit and file it with the court clerk. Most clerks will actually help you with that if your document needs a certain structure to be submitted. And you should get your affidavit notarized and be the belligerent. So what is a belligerent? Well, the privilege against self-incrimination is neither accorded to the passive resistant nor the person who is ignorant of their rights, nor to one indifferent thereto. Okay, so it's a fighting clause. Its benefits can be retained only by sustained combat. I'll repeat that again. Its benefits can only be retained by sustained combat. Okay? It can't be claimed by attorney. It can't be claimed by a solicitor. It is only valid when insisted upon by a belligerent claimant in person. There is case law to support this method, but I won't go into that here. If you want more information on case law regarding belligerence in court and that, maybe send me a PM. We'll go and do some research. There, I said it. So, the one who is persuaded by honeyed words or moral suasion to testify or produce documents rather than make a last-ditch stand simply loses protection. They must refuse to answer or produce and test the matter in contempt proceedings or by habeus corpus. Now, habeus corpus, that's an act of parliament which is still in force today, and that ensures that no one can be imprisoned unlawfully. Literally translated, habeus corpus means that you may have the body if legal procedures are satisfied. Now, this sounds like a strange phrase, but in medieval times it was the expression used to bring a prisoner into court, and it later was used to fight against arbitrary detention by the authorities. And the Magna Carta in the UK from 1215, that stated that no one could be imprisoned unlawfully, and the first recorded use of this provision was around 100 years later. But habeas corpus as we know it today was not made law until some 300 years after that. And although this law is still in effect, habeas corpus has not been continually used since 1679. In fact, it has been used in one or two cases I've seen, and even the Black Panthers use it as their defence in the US, actually. So it also has been suspended several times, and it was first suspended in 1793 when there were concerns that the French Revolution might inspire rebellion in England. And actually, there has been suspensions of habeas corpus several times in the 20th century. They use internment, that's detention without charge, and the USA, they're pretty much fond of this, but whatever the excuse, they'll do it. And during World War II in the UK, and World War I and World War II in the UK, it was used, and during many periods of the conflict in Northern Ireland in the later 20th century. And today, detention rears its beastly head in debates surrounding anti-terrorist legislation, where it's used as an excuse to detain people as the state sees fit. So research the following words, as I said I'd say at the beginning: affidavit, notarized, belligerent, belligerent in court, tacit admission, and assert. The simple word assert, A-S-S-E-R-T, but look for the legal term, and some of these points can be clarified for you. So I'll be doing more shows on how to deal with the police stops, and I'll be giving some pointers on knowing which key points to challenge if you're stopped and even arrested. And some of these can lead to payouts because they do carry a remedy, and they all do, in fact, when they breach the rules. And most people don't know their rights and they're not aware of this. My really good friend Clayton, he was actually awarded £30,000 for being arrested, and I was there to defend him in court, but we found a great lawyer who works for the people, and she won it on the fact that the police admitted to inform him which station they were from. So it was an unlawful arrest. Now, you only need to know a few things, but most of all you need to know is how to conduct yourself. It's all well saying, you know, fuck the police and getting into heated debates with them, but knowing how to conduct yourself can be the difference between a cheeky copper letting you go your way, a night in the cells, a beating, or even death. Forfeit the anger, forfeit shouting matches, learn your rights. I am the OBG.